on Liberia. Yeah. From Kemau to Cape Palmer, mountain back to Atlantic Ocean, Obomi Hills to Country, to educate, elevate, and promote. Talk about home affairs, hey, in diaspora, current affairs, reliable information, history, talking about culture, politics, education.
At Focus on Liberia, we discuss everything Liberia, from education to politics, arts and culture, entertainment, agriculture, history, religion, family, and technology. Focus on Liberia uncovers and showcases the best of Liberia and shows the world the truth about Liberia. We educate, elevate, and promote all things Liberia. We conduct interviews, panel discussions, debates, and more. Tune in to Focus on Liberia on Facebook and YouTube and be a part of the stories that make up the news.
This is Focus on Liberia, and I am Panelist.
And I am Anthony Sier, and welcome to Focus on Liberia. This is our program, FOL Justice Forum dedicated to looking at legal issues in Liberia. Please do us a favor and share the broadcast. We have two legal minds and two curious Liberians to probe this issue. We are discussing the Central Bank of Liberia case before the Supreme Court. If you are not aware, President Joseph Yamambwaka suspended without pay the executive governor of the Central Bank, J. Aloysius Talu, that happened on the 30th of January. Aloysius is not certified, and he believes the president is in error legally, and he filed a writ of prohibition at the Supreme Court, contesting that the president is acting in error, and he will not just allow him to be suspended in that way. He had lawyers, and the matter is now before the Supreme Court. So let me give you a summary of what happened. The Supreme Court has reserved ruling now in the writ of prohibition filed by the suspended governor of the Central Bank of Liberia, J. Aloysius Talu. The decision was announced by the Justice in Chambers, Youthful Kaba, on Tuesday, August 6. Legal team representing both sides presented their argument. The defense lawyer led by Councilor Tiawon Gonglo argued that President Bwaka's suspension of Governor Talu was unconstitutional and in violation of the financial laws of Liberia. The prosecution team argued that the president acted within his duty to safeguard national security. So the president is saying, well, I'm acting on national security grounds here. Talu is contesting his suspension and has filed a writ of prohibition against President Bwaka for wrongful suspension. The suspended CBL governor contends that the president's decision was unlawful and unconstitutional. Hey, the lawyers are here. I just thought to give a summary for those who may not have followed this particular matter. Co-hosting with me is Comrade Joseph Tao. He is a Focus on Liberia regular panelist on our program On Point. Seated and ready to participate is also Antonin Konyanen Freeman and Antonin Jason is here. Also, James Jason is here. Gentlemen, let me welcome you, starting with Jay Tao. Jay Tao, welcome. How you doing, brother? How's family?
I'm doing good. The family is doing good, and Houston is fine. We're just dealing with over 100 degrees heat over here. It was
Where are you? You in Texas or something?
Yeah, Houston, yes.
Oh, Houston. Oh, I see. That your state. You people going Democrat this election cycle or not?
I don't follow the domestic politics, so I
Yeah,
really
please leave that alone. It's full of stress. Well, let us welcome Anthony Jensen. Anthony Jensen, good evening. How you doing, brother?
Well, I want to say thank for the invitation, and I'm happy to be here and to join the other two professional brothers so that we can deal with the issue. I have a position, and my position is that the president of Liberia, this is not what I like Walker or what I'm a UP partisan or not, which of course I'm not. But I think Joseph Walker has the right in this matter. The constitutional authority granted him to appoint and dismiss. Indeed, is if he decided to exercise that, I think he's legally correct. And so why, and of course I'll be explaining why as we go further into the show.
All right. I like that you have taken a position. You believe that the president acted within his right and powers as president to suspend. Anthony Freeman, welcome and welcome enough. What is your position on this matter?
Well, this presents a kind of gray issue. And by gray, I mean there may be arguments on both sides. But I am more of a black letter law kind of person. So I will go by the letter of the law. And so by going by the letter of the law, I will stick to the position that what is written in the law should be followed literally.
All right. Now we have a discussion, and gentlemen and folks in cyberspace, if you are just joining us, please do us a favor by sharing the broadcast. I have questions as a curious mind regarding this matter. It is said that the president of Liberia has the right to appoint, and it's also said that whoever is appointed by the president serves as a will and pleasure of the president. However, there are laws that have been enacted to not allow the president to act in certain instances. One of such instances is the case we're discussing today with the Central Bank of Liberia. So now that the president has acted, and he's saying that he has acted based on security ground, on national security grounds, something serious is happening, and he's trying to prevent that from happening. Let me get to you, Anthony Jensen. You said that it is within the president's right to act. So the act creating the central bank is clear that the president cannot remove any of the governance of the Central Bank of Liberia. Some legal minds are arguing that suspension is a removal. Do you believe that the president acted within his right and was not unlawful in his action?
Well, thank you so much. The Constitution is very clear, right? And I will present a theory that will convince any rational legal mind that the president acted rightfully. As much as I'm not a lawyer in the case, and I'm glad you said they have already argued and the ruling is being reserved. So meaning whatever I say here, no lawyer going to capture that and say, well, this is my position. Then we'll say, okay, Jensen knew that this case was in court and then he went discussing this matter. But here's the point. The Constitution was written by framers. The people of Liberia gave right to certain Liberians to draft or to construct the Constitution of Liberia. Impeachment that is being hung on by the governor of the central bank, he has no right to even go that route because impeachment is being clearly spelled out by the Constitution of Liberia. And it is specific to say that those who are to be impeached are named by the Constitution of Liberia. They include the president of Liberia can be impeached, the vice president can be impeached, the chief justice and the associate justices can be impeached, judges of court can be impeached. Now, there is no granting of that authority, the power that is inherent in the framers, to which they say the president can be impeached and all those persons can be impeached. There is no constitutional provision that gave Congress or the legislature the right to extend to other public officials the act of an impeachment. Hence, the governor of the central bank cannot hang on impeachment, because impeachment, let us assume that the central bank act that created that institution, I remember that was 1999 when Taylor decided to form his own government, all that stuff, the act creating the central bank. It is said that the governor of the central bank cannot be removed except by impeachment, meaning then that even the lawmakers were not clothed with the authority to say that in the law. Because impeachment is something that is with the framers, is not with the legislators. The legislators have a specific duty. They can investigate any body that is in government, and they can act on by making, either by resolution or by some special order to say, look, Mr. President, our findings, our investigation require that this your minister be removed from government. Or they can sign a resolution to declare a vote of no confidence in any official that they think is very corrupt. But for the legislators to go ahead, even Congress, the US Congress here, they cannot ascribe impeachment to other positions, because impeachment is an authority.
Anthony Johnson,
yeah,
I know you will continue on. The law, the act that created the Central Bank of Liberia, was it signed by the president?
Yeah, let us assume, yes, it was signed by the president. But the president himself does not have any right to say that the lawmakers can pass a law that other public officials can be impeached. Because let me say this again. Impeachment is a long procedural step. There must be a bill of impeachment passed by the House of Representatives to tell of the membership of the House.
But my question is on suspension, right? Because the act does not provide any room where the president can suspend any of the governors at the Central Bank of Liberia. That is what President Bouakai has done. So what is his reliance? What is the precedent here?
The Constitution of Liberia gave the president of Liberia the appointing and the removal power is with the president of Liberia.
But now, in the case of the Central Bank of Liberia, that power to remove is, it's rested with the legislative branch of government.
And that's the error there. If the Constitution says appointing any official of government is solely the responsibility of the president, and removal of any official of government is solely the responsibility of the president, I would then have advised, if I was a lawyer assigned to those lawmakers, I would have said, well, you cannot undo what the framers have assigned to the president.
But Anthony Johnson, you are aware that when it comes to impeachment, removal, that is rested with the legislative branch of government.
And that's why I hope we all understand this. Impeachment is described in the Constitution of Liberia. Not only described, impeachment says those high places, those public officials who are in high positions, and I named them, or I don't need to go over it, and you know them. Yeah. The Constitution says those who are supposed to be impeached. So if the Constitution wanted other officials of government to be impeached, the framers would have said it in the Constitution. They started naming 1, 2, 3, 4 must be impeached.
Jason, didn't the Constitution also say that the legislature shall enact laws, and this law creating the Central Bank of Liberia, don't you think is one of such laws and that should be respected by the president?
The Constitution further says, they're not going to stop there. Any law that is created by Congress or the legislature that contravenes the Constitution is not void.
So how does this Central Bank Act contravene the Constitution when it comes to suspension and removal?
That's a good question, and I've already answered that, but I will repeat myself. The Constitution says the president of Liberia, not Judge Joseph Boakai, the president of Liberia, a sitting president of Liberia has a right to appoint and remove. Now, if the lawmakers went ahead and created an act called the Act of the Central Bank and incited in that law that the only way we can remove the governor of the central bank is by impeachment, there are two things they have done right there. They have abrogated the right ascribed to the president. They have also taken some of the authority the framers have. That impeachment, that word impeachment that we're playing with, is not supposed to be given or ascribed to any other position in government. There's no provision in the Constitution of Liberia. I want any lawyer, Councillor Gonglo, I want any lawyer to say the president, not the president, the legislature, by right of saying they have a right to make laws, meaning they can go ahead and take on the authority of the framers and ascribe impeachment to other positions in government. I don't think any lawyer can tell me that.
Thank you.
So because impeachment is a special act and there's a procedural step, the Chief Justice must preside when there is an impeachment. Do you want the Chief Justice in the high place to come down and sit and preside over the removal of a governor? No. Even the Speaker of the House, there is no provision that says the Speaker should be impeached. There are removal proceedings. There can be an investigation. Even Congress has a right, like this matter that is lingering in Liberia. There should have been a very important legislative hearing to dig out the facts. And when the facts are dug, then the next thing that needed to be done is either the legislators themselves could pass a resolution, either a simple resolution or a joint resolution that would have said, look, we have a vote of no confidence in the governor. Let the governor go to court. I'm not sure the Supreme Court herself will agree that the Chief Justice of Liberia must go and sit down over the hearing of a central bank governor. Meaning impeachment cannot be given by Congress or by the legislature, even in America here.
Thank you.
Yeah.
Thank you. Anthony Framer, what is the argument of the governor legal representation in this matter? I know they said that this is unconstitutional. The president is unlawful. He acted unlawfully. But what is that legal backing to prove that the president acted unlawfully?
I wouldn't say unconstitutional because the law that they are claiming was violated is a statute. So when you violate a statute, it's a violation of law, but it's not unconstitutional. So just a little correction there.
So you are disagreeing with them because in their argument, they said the president acted unconstitutionally.
It could be they made constitutional argument, but the central bank law is a statute.
Okay.
You just follow the logic. The central bank law is a statute. So when you violate a statute, that's a statutory violation. In order for you to be accused of an unconstitutional act, you have to violate a specific clause in the Constitution. So if they are citing a constitutional clause that was violated, then you say it's unconstitutional. I'm saying that because generally people say it. They kind of mix violations of law or regulation statute with constitutional violation. The two are not the same. In order for there to be a constitutional violation, there must be a specific clause in the Constitution that is violated. So if that does not happen, it may be unlawful, unstatutory, but not unconstitutional. That's the point. Okay, so what we need to know is there are two aspects to legality. There is the substantive law, say the CBR Act, or maybe the penal law, and then there is the procedural law. All two must work together in order for an action to be legal. So you cannot say, okay, this guy committed fraud. Then the law laid down a procedure for you to follow, and you say, oh, no, he committed fraud, so I'm not going to follow the procedure. Your action will be illegal. Your action will also be illegal if you follow the right procedure, but maybe the person didn't commit the fraud. It will also be illegal. So in both instances, all two. That's why, for example, in the case of Janet, they said they followed the procedure. They went through the house, they had a trial, but when they went to the ECOWAS court still told them that they were wrong because his substantive due process rights were violated, but they went through the procedure. So the procedure was correct, but the substantive law was violated. So the wrong things happen at the central bank? Yes. Do I think it's possible crimes were committed? Yes. But I think the best alternative for the Bouaké regime was to send that information to the Ministry of Justice or the LSCC. They will have investigated, and had they come up with criminal activity on the part of the governor, they will have charged him with a criminal act. When the governor is charged with a criminal act, it will be incumbent upon the board to suspend him, because he cannot be charged with a criminal act and be conducting the affairs of the central bank. But to leave that, even the limited procedure for audit and other things that the House has to debate, they have to hear it, you leave all of that and you just go ahead and remove it when you know very well that it's not within the act. But if you are charged with a criminal act, you are brought in under the penal law. And under that, the board will have said, look, if you are charged with a criminal offense, you have to be suspended and you pursue and your criminal act, and when you get through, you can come back, stuff like that. You know, because even under corporate law, it is the board that has the responsibility to act. You do not set up a board, then while the board is active, then you go and take a decision. No, that's not what the essence of forming a board. You form a board so that they can take an action on the administration. Mm-hmm. So, you know, I mean, those are things, but it's typical with this regime. They have just been going from one violation to the next. So it's not unusual for their behavior.
So before I can bring Joseph in, my next question to the both of you, they said the Supreme Court reserved ruling in a writ of prohibition filed by J. Elisha Taylor. For the ordinary man, what does that mean? Because there was a matter carried before the Supreme Court, but they are saying the reserved ruling. What does that mean? And what's the implication of that? You can go first, Anthony Freeman.
Okay, so the first thing we need to understand is the prohibition. Mm-hmm. The prohibition is when you move against somebody who maybe presumably they have a right, mm-hmm. but maybe they don't have an extent of the right that they are claiming, or maybe they don't have any right at all and they are claiming that you want to stop them legally. When you submit your matters to the Supreme Court, normally the Supreme Court will want to research the law, research prior opinions, you know, and then before they come up with a ruling, so that takes time. So that normally is why they will say we reserve ruling, because they have to research the law, and as you know, they vote. Each person has to come up with their own view of what is going to happen and then make a decision. For example, I just put in the private chat a case from 2008 where the Supreme Court said that the Constitution does not recognize suspension versus permanent removal. All two amounts to a removal, and in order for you to remove, you must follow the due process of law. That was in 2008 in the case of NDPL versus House of Senate. So the court would normally say, look, okay, the party go, you made your argument, give us your argument, we will look at your argument, we'll research the law, we research prior opinions, we look at the Constitution, look at the different statutes, and we make a decision, and that takes time. So that's what they mean by reserve ruling.
Anthony Jensen, you want to throw light on that when they said the reserve ruling? What they're talking about? How can that be interpreted?
Every term of court, the justices or the Supreme Court decide who should be in chambers. In this term, I think Justice Kabah is in chambers. So if you heard the parties, like you said, I haven't read the story, that you just read. But if the parties appear before the justice in chambers and he heard both arguments, he gets about saying, well, he reserved it because he could stay right there and announce his ruling as to whether or not he will sustain the petition that went before this Honorable Supreme Court, barred him through the justice in chamber, or he would deny or he could grant it. And even granting it, the matter can still go before the full bench. So at this stage, if Justice Kabah has heard the lawyers from the two parties, all he's doing is, well, look through the facts. Normally, there are facts presented before the justice in chambers, and then look at the issue thereby, make his own analysis, and be able to say, okay, well, with all of these facts before me, with all of the law, the controlling law of the issue raised, he can come up even tomorrow morning or anytime at his own accord and say, well, from what, then you send out the citation, and the very lawyer will appear before him, and then he will announce his ruling. But there's something that I wanted to say that Freeman talked about. The issue of matters going before the court, or the issue of constitutional matters and matters relating to the statute. In this case, when we're talking about suspension, there are reasons why administratively, anyone who being in administration will understand that the president could not go ahead with removal because removal is a constitutional act. That requires a lot of things that could be challenged. But suspension is an act to say, well, we would say, look, Mr. Man, I don't just want to dismiss you or remove you from your office, because that probably would have been the constitutional argument. But the president is saying, look, until we gather all of the facts as to whether you are right or wrong, or you find you acted rightfully or wrongly, please just go and sit down.
Well, Anthony Jensen,
but that is a problem. I don't know if I can jump in.
If I may rest first, right?
Okay. Let me point there.
Suspension is not an act provided by the Constitution of Liberia that says, well, the president must suspend. But administratively, the president has far-reaching power over those persons that he appoints. So if he decided to say, I'm suspending you pending an investigation, it's just an opportunity given if the governor. But if the president had taken an action to remove him, meaning he had no chance to go back there, so he can then go and challenge the president's authority because it's provided for in the Constitution. But if they say, look, you are suspended, that suspension is just an administrative action. It happens all across. Even in America, they can decide to suspend somebody, meaning they have not had a clear reason for your removal. Investigation is ongoing. But just for the purposes of the people's right, the people's power given to the president take an action. My man,
it's wrong
on three different levels.
In this case, he has suspended him.
Well, you say I could jump in?
Pay. Yeah, but he the moderator and I listen to his
he has suspended him without pay. My experience is that if you are suspended, when all the facts have not been looked at, all right, then you maintain your rights, your benefits. But
no. He can be suspended with pay, or he can be suspended without pay. Let us assume that he win all his cases. If they didn't pay him for 10 months or 1 year, they will collect all your money and give it back to him.
Okay. Let's bring Anthony Freeman in. Go ahead, your point.
So let's start with statutory law, the Central Bank Act. You know, in Liberia, Unfortunately, people just say the law say. The law say must always be based on a specific law, either the Constitution, statute, common law, corporate law. It has to be based on specific law. So if you say he has a right, you have to be specific. Which law allows him to do that? Because under the CBS statute, well, he doesn't have that leverage. Now, if you go by way of corporate law, when you set up a board, the board becomes the highest decision-making power. So you cannot set up a board and you leave the board and you start acting. So under corporate law, he is wrong. Okay? Also, too, he had an alternative. That's why I said, if you allow the LSCC or the Ministry of Justice to have investigated and they had charged him with a criminal act, then under the penal law, or he cannot be presiding over the central bank, you know, why that? So the board is going to likely say, my man, if you are charged for criminal act, you have to pursue it. So for you to say that what he did was lawful is to say specifically what law allows him to do that. But statutorily, he doesn't have that. On a corporate law, which is you're dealing with board matters and chief and CEO matter, he doesn't have that. You have not done the investigation under the penal law, so you don't even have that leverage. So actually, it's not surprising because, I mean, this is a man who can bring in multi-million-dollar equipment under a gentleman agreement. So he's just used to violating the laws in the country. But for him to have done it, he must be able to say which specific law grants him that power. It can't be vague. I already cited a case law to you, which is also law, that in the NDPR case versus House of Senate, the Supreme Court said there is no such thing as temporary removal and permanent removal. A removal is removal. It must follow the due process of law.
Thank you. Let me bring in Joseph
a point of correction before you
hold on. Let Joe ask a question, except he wants to give you the opportunity to do so. Joe?
Okay, let him clarify that, then I will come with a question that I have for both of them.
Go ahead, Anthony Jensen.
Okay, thank you, Joe. Here's the point. All of us that went to law school, I do not have to know financial law. I do not have to know corporate law. The basic fundamentals of law have been taught each and every one of us that went to law school. What do we need to do is to understand a specific facts and circumstances bordering a case. In this matter, Joseph Boakai has acted. What was his action? Suspension of the governor of the central bank. What happened? There is a massive amount of money that is in question. What further happened? There are other officials of the central bank, and people acted by disbursing huge amount of money to people outside of the central bank. Those facts and circumstances, you and I must be able, if you want to law school in briefcase, we're not about knowing almost other things in the book, but there are specific issues that we need to know. What are the issues bordering this matter? The case that went before the Supreme Court, there are few questions that Justice Kabah would have asked them. And I know all of the lawyers that went before Justice Kabah, they knew what was the issue that the court will want to understand and raise and be able to find the necessary law. Now, that's an issue over there. When you get all of the facts and circumstances of a particular case, now, if the case bordering constitution, then in this matter, there's a matter of removal, suspension, and there's a specific word that came in the facts that says impeachment. Now, hearing the how you call him, the central bank governor, he's relying on what? Impeachment. So his petition that went before the Supreme Court is that he feels strongly he should not have been suspended because the law says, the statute says that he has right, and until impeachment is done, he cannot be removed. That's his argument. So what is the issue in there? Under what law will you want to go and search? The Constitution. The president is involved. The president has what kind of power he has? Is that statutory power? No, he doesn't have statutory power. He has constitutional power to act on those officials.
Thank you.
So then, if we go in by that route, we ask the necessary question: what law like you myself now, if you were in this case, what were you going to do? Which book will you take first?
So, Anthony Johnson, your argument is that when you have the statute and you have the Constitution supersedes. So once the president action in your argument is constitutional, we shouldn't worry about the statute. The statute does not matter here.
No, that's what I'm saying. Every lawyer must be able to defend his client to the best he thinks.
All right.
What I'm saying, the statute involved, right, and the Constitution involved. I can see what the statute said. I say, well, the central bank governor has before he's removed, he must be impeached. If I saw that in the statute of the central bank, and I saw the Constitution that said the president of Liberia has the power to appoint and to remove, which law do you think I'm going to rely on?
Thank you.
While I will be relying on the Constitution, I will also cite the Central Bank Act that said this is what the lawmakers failed to do. They knew very well that there's a constitutional provision that gives so much right to the president.
Thank you.
Yet they want to create a piece of law that contravenes the Constitution, so it is null and void. Hence,
thank you.
May it please Your Honor dismiss this case on the ground that whatever law that those people, let me be careful my words here, whatever these lawmakers said, giving right to the central bank is not a void because the Constitution supersedes. Any law that contravenes the Constitution is not a void. The last thing I would probably say, the governors have right to investigate matters, but under these circumstances, they could not. They even let assume Baka did not act. All they do is they would have investigated and sent a matter before the office of the president.
Anthony Jason, thank you.
Is an agent of the president. The board cannot act on him. That's what
Anthony Jason, thank you.
Yeah.
Joe?
Okay. Yes, gentlemen, I have two questions that I will need some clarification on, at least some insight on, right? Okay, so I see both sides of the argument, and I listened to Councillor Jensen, and from what he's saying, that the constitutional act that listed everybody from the Constitution, which is highest law, that where impeachment can be applied, right, the officials. And then there is an act that then created this. My question is, should there be an act that actually take away the president's authority to remove an appointed official by the president, as in the central bank case, where the president is going to appoint somebody, and this person is in this position, and they're misbehaving, or they are not performing the way they're supposed to, which then have a detrimental effect to the entire future of the country. And then there is something that blocking the president, that even though you appointed him, but now you can't remove him. You must go through all this hoop. That's one. The second question, and I can answer in whichever order. The second question is, from what Councillor Freeman said, which is in the central bank, that the board, in corporate law, right, the board is the highest authority, that the president should have gone to the board or use other means. But what does the president, or why is the president required to do? If from what I've seen, the discussion I've seen on some platform, that for the kind of money, because I saw the whole tally sheet coming out, that there was no way that the board was not aware of these actions. So if the board itself might have been implicated, how could they have really been trusted for the president to go to them to actually judge themselves by trying to rule against the guy who they were all acting with?
Okay, you finished?
Yes.
Part of the reason why when we go to the Supreme Court we cite precedent is because it's not really belaboring the point. We already had extensive argument on tenure.
Yeah.
And then finally the Supreme Court came back and said we have made 3 different rulings in tenure and we stick by our ruling. tenure is constitutional. So we can't reopen the tenure argument. So is the president power limited? Of course. That's why you have 3 separate and co-equal branches. So the president power is limited. Also to the Constitution, there are self-executing clauses and there are non-self-executing clauses. When the Constitution gives you a right to education, how do you access that right? Well, the legislature has to pass an education law. They access your constitutional right to education by way of the education law. The Constitution grants you a right to employment. But you can't just go and you have to go through the labor law. So for anybody to say because something is said in the Constitution, it means it is autumn. No, unless it is maybe a self-executing clause. But most of the clauses in the Constitution, in order for them to be executed, they need a statute. So when a statute is passed, signed by the House, and it limits the power of the president, so be it, because the law grants the legislature the right to pass statute that will further execute constitutional mandate. So the Supreme Court, you're coming. So the Supreme Court has already decided that the president power can be limited. That argument is closed. The other point I want to say, when you have, like I said, the president had the option to go by way of the penal law. By going by the penal law, it means he did further investigation and he charged the governor with a criminal act. Then they could have, the board could have suspended him based on the fact that he had criminal charges. If he wanted to, he could remove the board. That is his authority. But when the board is in charge and in place and is functioning, you cannot pass by the board and go to kind of act on the CEO. No, you got to stick to, because corporate law is also part and parcel of the law. So what I'm saying, when the statute is deficient in a way, like in this case, they didn't mention suspension, then you put in other law. Maybe you put in penal law, you put in corporate law, you put in administrative law, okay? You put in case law. So you bring all those things to bear and say, okay, even though this thing is missing from the statute, but what does case law say? I just cited case law to you, NDPF versus Senate, that there is no difference between suspension and removal, permanent removal. They are the same. When we go by way of tenure law, they're also telling you, no, when somebody has tenure, they have tenure, you have to follow the law. If you bring in penal law, that means you have to charge this man with a criminal act. And if you go by administrative law, you can set up a board and then bypass the board and take action. So on so many fronts, the president is just wrong. And but it's not surprising. Like I said, since the guy been in power, all he's going to be doing is violating from one law to the next. That's all he's been doing.
Hello, can I make some corrections?
You're free now.
Yeah, go ahead, Anthony Jensen, and be patient. One at a time. Go ahead.
I'm very patient, but sometimes if there are some pieces of information that seems to be, now let me be careful my word, I'm talking to my colleague, right? That seems to be misleading. We have to make the corrections for the purpose of the show. The Constitution of Liberia is the highest law in the land. When the Constitution speaks, you cannot go to the statute. You can't be talking about case law. You can't be talking about the different branches of law. Anywhere in the world where you have the Constitution speaking, like in this matter, it says, Article 54 says the president shall nominate and with the consent of the Senate appoint and commission cabinet ministers, deputy and assistant cabinet ministers, ambassadors, ministers, consuls, and you name the rest of it. When the president appoints a board and appoint officials of an institution, Joseph Boakai, whether we like him or not, he can wake up at this moment and dismiss all of them. If anybody feels dissatisfied or feel that his right has been trampled on, you go to court. But to say Joseph Barker will be afraid of the board cannot. Let me say this again. Maybe before you can go research. The board cannot suspend or remove an official that is appointed by the president. The board has a right to investigate and submit their findings to the president. And the president has the ultimate authority to take an action. Not that they will go and say, well, Mr. President, or go, because the president is in violation. Why would you even say the president is in violation of what law? The Constitution of Liberia? The Constitution of Liberia is very specific to this matter that we're talking about. The president has not acted wrongfully. However, the right of the man who feels
that's why you need a side law. You can't just be talking around without citing any specific law.
Article 54. What else you want me to say? I'm gonna go to penal law.
Anthony Jensen.
Penal law issue here.
Anthony Jensen, I have a question.
Yeah, ask a question. I will answer it.
So, how does the suspension of the governor safeguard national security, as argued by the prosecution team?
Well, that's another fact, right? I said I'm not in the case. So if the prosecution went ahead and said, well, or for national security reason, maybe they themselves, I'm not supporting anybody here. I'm just depending on the Constitution here. Maybe if their argument were wrong, let me say this to you. It doesn't mean that what I'm saying here is what they argued before the Supreme Court. Mm-hmm. But if their argument was, oh my God. What if their argument was based on falsity of facts? Even the fact presented, if they didn't present it rightfully, if they did not raise the right issue before the Supreme Court, for the court to reason with them, if they did not make the necessary citation and defend it, they could lose a case. They could lose a case. So you can have all of the case in your favor, but if you don't do your research, you don't know how to find your law, you don't know how to raise an issue, you don't know how to argue, you don't know how to make a recommendation, or you present your findings. For the court to see you that say, yeah, this is a good lawyer, he has presented his facts, trust me, you can lose a case on this ground.
Anthony Johnson, you understand that this is a turning position, right? Hold on, Anthony Frank. You understand this is a turning position, right?
Are we discussing the issue of turning?
It's close.
Listen, I ask a question.
I will answer your
turning position, sir.
Listen to me. I'm going to argue that. I'm going to answer that, right? Mm-hmm. Let's assume that the president of Liberia was elected for 6 years, and the president of Liberia acted wrongfully, and by committing some felonious act. Mm-hmm. There are laws that say what should happen to him. Let's assume the governor had a turning position, and the governor, by any means, siphoned state resources, and those glaring facts are there. And the president don't want to just say, look, you stole this amount of money. He wants to further investigate. The president took an action to suspend him. That has nothing to do with his turning position.
But the reason I asked the question, Anthony Jensen, because the statute is clear how a turning position individual can be removed. And the president of Liberia, who believes in us, you subscribe to the rule of law, should follow that path. But in this case, he's using national security, and that's what I asked the question earlier.
You can use the argument I was presented before court to be the reason why the president suspended this man.
But this is the persecution.
I agree.
That's saying this is
but
this
no
is the
no. You now, as the journalist, you should pick up the memo that came from the president's office that said you are hereby suspended for A, B, C, D reason. I agree whatever the lawyers argue on there.
And they said based on the audit report. That's why the central bank governor, the president letter said that.
Granted.
Based on audit report.
Granted.
But and then the audit report talk about compliance issues.
Yeah, but granted.
And it's based on the compliance issue, and the president is suspending him. So the cause here is failure for the central bank to comply. And so the individual who is the turning positions is being removed when the statute lay out process through which the person should be removed. And that's why the legal team of the central bank governor is saying the president has acted unlawful.
What was the petition that went before the court? Do you know the facts?
Well, we don't have the petition, but I don't know.
but I'll give you a few minutes. But here's the issue. The major issue we found from the petition that came from the central bank governor was that he should not have been removed or suspended because to do that, he is there because he must be impeached before removal. That is argument that went before the court. So that part of the facts, including what the president's action has been. So you take all of those facts, you raise an issue. Either I would say, well, the president's action is what is in contention here.
Another question I have, Attorney Jensen, is the separation of powers, right? Because based on the statute, to remove the central bank governor, it has to be the legislature. That power of remover has been assigned to the legislative branch of government. If President Bouaka respects the separation of power, he can take the matter to the legislature to do so. So if I may ask a question here, does the president action infringe on the principle of the separation of power?
No, it did not. No, it did not. And I read for you Article 54, right? That said the president shall nominate with the consent of the Senate upon blah, blah, blah.
Read that thing over and over.
Yeah, read it so that you can better understand it.
No, don't need to read it over and over.
The president shall appoint and commission
does the Constitution you rely on talk about
because you're going back to
can remove power?
Yes, remove.
We cannot go back to something that the Supreme Court has decided. That would be like wasting our time. The Supreme Court have made it very clear that tenure is constitutional, is legal. So to go back and restart that argument is a waste of our time. It's a disservice to the audience.
Is that the issue before the court?
But that's why you bring it. That's the argument you bring it.
He asked a question.
You are making the argument that the president, based on Article 54, can do as he wants. And the Supreme Court has said, no, you cannot do as you want because tenure is legal. When somebody is given tenure, what is stipulated in the statute, you must follow it to the letter. That decision has been made. So why are you taking us back?
And Anthony Jensen, to Anthony Freeman's point, when the Supreme Court handed down that ruling, the president came and made a statement. I think it was a speech that he respects the decision of the higher court. The next day, he suspended.
Yeah, but you know why? I think,
and this is what he has done.
I wouldn't blame you, Anthony, for raising this issue. But a Freeman who sat here as a lawyer will say because the Supreme Court has spoken, meaning you cannot go back to a particular issue, then I will be baffled. Why? Because a matter of tenure being part of a set of facts, any lawyer can raise series of issues and address them and leave those issues with the court to make a determination whether there has been a case decided before or not. Now, the facts before us here, what is it? There are two parameters I'm getting here. The president acted, the governor disagreed, and the governor run the court. Don't we talk about tenure?
It is tenure because you are telling us that there is no limit on the president's power. And tenure law says there is limit on his power. And the tenure law says when the statute says you must follow step A, B, and C, you have to follow step A, B, and C to do what you want to do. That's what the court has said. So why are you taking us back?
The issue that went before the court is not about tenure.
That's why it was the court decided tenure, and the court said you must follow what is written in the statute in order to remove.
One at a time, gentlemen, please.
Do you have the petition that went before the court? You don't.
I'm not on the current petition.
No, you are adding.
When you keep raising argument that the president's power is unlimited, I said no. The president does not have unlimited power. The tenure law has already established that he doesn't have unlimited power. So why are we going back to something that has been decided almost 5 different times by the same Supreme Court? Why we have to continue with that discussion? He doesn't have unlimited power. His power is limited, and the Supreme Court can limit his power. The legislature can limit his power. So he doesn't have unlimited power. So when the statute says follow step A, B, and C, carry on impeachment, that's what the statute says. You have to follow it.
Authority to make a piece of law that will restrain the president's power. The Supreme Court of Liberia has no authority to restrain the president's power.
They interpret the law. And when they interpret the law, it's final.
They cannot make any piece of law that will restrain the president power.
Oh man, we're going back to the same thing, man. We don't come there to discuss. The president has limits. We don't have a king. It has limits.
Anthony Jensen.
Ask a question because I don't know where we're going from here.
So, are there any previous cases or legal precedent that could influence the outcome of this case?
As far as I'm concerned, the Constitution of Liberia controls this matter, and watch out for the result that will come out. As far as I'm concerned,
asking you for precedent and previous
no,
cases.
but I'm telling you, if I was a lawyer in this case, my big reliance would be the Constitution of Liberia. So I will not waste my time to go look for penal law or this and that. We don't go to penal law on this kind of matter. Talking about corporate law, we're not going to corporate law because the facts presented before us has to do with the
those are our laws. Those are laws that were enacted by the national legislature to be used. So why are we not using them?
Because the facts presented deals with the presidential power. The president took an action. Take that as it is. The fact, the major fact in the case, the president took an action. Then the man who took action on disagrees. He runs to court with a petition. Says, though, the president's action was wrong on me because why? The law says I must be impeached. That his argument, he didn't go there for tenure. So when we sit on the Facebook, social media, and causing our own noise here, it has no bearing on the set of facts that the man.
What is a writ of prohibition?
The writ of prohibition is to say, well, we want to control the president's power. That we say prohibit the president from taking an action. The president took an action, the president should not have taken this action. So stop him. That's what the man praying for. Stop the man because the man is able to suspend me.
So similar prohibitions were filed against this very president, and he lost those cases.
Oh my brother. I don't know what do we do again. Do we take other cases and discuss it here, or we go by the case? We get set of fight. That what came for.
Because right? Anthony Johnson, you understand precedent. You understand that when the Supreme Court gives
I have told you, and let me repeat myself.
Any legal matter where we don't have clarity,
precedent is not higher than the Constitution of Liberia. Precedent. I will go to precedent when I don't have any. This is what we do. I don't blame you the way you're asking the question, right? But this is how lawyers will act. You get a set of facts. The first thing that comes to your mind, the facts that I have before me, the issue you raise, cannot find my answer or what I want to find to depend on. Cannot find in the Constitution. If the answer is yes, you don't go pick out statute either. If you have answer in the statute, you don't go for precedent. If you check all of the book, you don't see nothing, then you go for precedent. That's how good lawyer will do. But you leave the Constitution. This is a constitutional issue. Why are you going to the statute for?
So how is the president's action constitutional?
And brother, anytime you say the president make an appointment or the president remove these two words or suspend, the only book you will find out first is the Constitution of Liberia. There is no law down there. Even the Supreme Court has defined other things down there, but the law is what you look at. The Constitution first. If the Constitution does not answer the specific question that you want, the question you must be asking, you're not a lawyer, sorry. The question that everybody will ask, does the president have any right to suspend the central bank governor in the face of the statute? If I say yes, then I'll say, well, okay, what is the law that will convince the court with? Then I go in the Constitution and search all my constitutional things.
So your argument when it comes to the president and looking at the Constitution, the president can do whatever he wants.
As far as appointment and removal is concerned, the president can beat his chest and suspend anybody, anytime.
And remove anybody. Even though the statute is there for the president to use.
The statute is there on the president
for the administration of a particular agency. There's a statute passed into law that the president should use.
All agencies of government is created by statute. There's no question about that.
And those statutes ask for the use of the president as the executive branch of government.
No, the statute spelled out primarily. Let's say, for example, the central bank. The act of the central bank addresses how to form the central bank and how many governors should there be. What are the authorities of the governors? Talk about the board of directors of the central bank. What are the duties and functions of the board of directors?
How they should be removed.
Yeah, actually, I don't see us going very well with the conversation.
Yeah, because you don't have a
I
point.
see us going very well with the conversation.
It's not strange in the courtroom. When you're a lawyer, you don't have a strong case, you don't have a good law to rely on.
No, it's not about me having a good case. I'm saying to go to court, we in law, we call it stare decisis. When a case has been decided, then you come back to the court and ask them to decide it again. It doesn't make any sense.
So I don't think we have.
So
I don't have
we have established that the president does not have unlimited power because we run a republic. The tenure thing has gone to the court more than 5 times, and the court has come back on that 5 occasions and say it's legal. The president does not have overwhelming power. When the law establishes tenure, the president must act within the tenure. So to come back and spend almost an hour talking about the president unlimited power, I don't think you are doing justice to the. I mean, you've been talking for long, so give me a chance to make my point.
But you keep messing it
up. Let me make my point because you've been talking for long.
This is not a tenure case.
Go ahead. You were coming.
Yes. So we're spending almost an hour talking about the president power. The Supreme Court already decided that he doesn't have unlimited power. So let's look at other angles of it. Because here's the thing, right? That's why when I started, I said there was a gray area. Gray area means if you look at the letter of the law, suspension is not written in there. But the facts and circumstances can make suspension legal or illegal. It is that fact and circumstances that can bring in case law. It may bring in the penal law. It may bring in administrative law. It may bring in corporate law. Okay? And if you go to court, the law are intertangled. There is hardly a situation where you go to court and say, I'm exclusively dealing with this law, especially when it's around maybe statutory issues. So they may bring in what we call usage of trade or something like that. Well, how is it done? So administratively, yes, you can have, or if it's not written in the law, then we want to find out what authority, but it still has to be based on some legal authority, either case law, like I said, administrative law, corporate law, penal law, or something. But it has to be based on some law. It can't just be based on a blanket statement that the president has all power when the Constitution already has said the country does not have all power. The Supreme Court has said the president does not have all power. The statute is emphasizing that the president does not have all power. Then we keep stressing that the president has all power. That kind of legal argument, I mean, I don't understand where we're going with it.
I don't understand the facts. Let us assume you were the lawyer in this case. What issue were you raised for which you go further down to go look for or whatever you call or tenure? What the issue you can raise in this matter that will reference any other law other than the Constitution? I challenge you right now to raise an issue for which you will leave out the Constitution in this matter. Raise an issue. The fact is no. Raise an issue as a lawyer.
I just mentioned to you.
What is the issue?
I just mentioned to you case law.
Why you talk about case law? Raise the issue for me.
You ask questions, you say you challenge me. So when you challenge me, you must give me a chance to answer you. You pose a challenge, so allow me to respond to your challenge. Okay, I don't think you want me to respond to your challenge because you can pose a challenge and now allow me to respond.
You're citing law. I don't say cite law. You must raise an issue for us to talk about the law. So what is the issue you can raise with the facts presented before us? Because I don't want all of us to leave and mislead the people.
If there's any misleading going on, most likely it's coming from you.
Okay, I take it as that get people listening to us. They get people listening to us, not because what you say or what I say.
All right, folks in cyberspace, if you are just joining us, we are discussing the Central Bank of Liberia case before the Supreme Court. The Supreme Court has reserved ruling. The president of Liberia, Jose Yimam Bouakar, I believe on the 30th of January, suspended J. Aloysius Talu, governor of the central bank, and he feels that the president acted unlawful because he believed that for a central bank governor to be removed, it has to be done by the legislature based on the act creating the Central Bank of Liberia. So he prayed for a writ of prohibition, and the matter went before the Supreme Court. There was a conference, and then the Supreme Court has reserved ruling, meaning they don't have a decision at this time after hearing from two sides in this particular matter. So that is the issues we are discussing. Anthony Jensen is saying the president, as much as he has the right to appoint, that power is also within his means to suspend or fire. Anthony Freeman is arguing there is a statute, and the statute is saying to remove the central bank governor, the person must be impinged. There are other laws that you can use. If you think that the man has committed a criminal offense, then of course there should be a charge, a criminal charge against him. Then based on that criminal charge, the board can act to remove him. But Anthony Jesse is saying, no.
The board had no
The
authority.
president supersedes the board. In fact, that the president appointed the board, he can
dismiss at any time.
Can I read a section from the CBL Act?
Please, go ahead.
Section 22,
Mhm.
removal from office.
Mhm.
A member of the board may be removed from office by the Liberian Senate only upon impeachment filed by the House of Representatives upon a finding by a majority of the Board of Governors and the recommendation of the president.
So,
the first thing, like I said, under corporate law, it is the board. You can set up a board and bypass the board. You set up the board. It is the board that is going to have a finding that something has gone wrong. That's what I'm saying.
Did you understand what you
if you
just read?
feel, counsel, let's do this thing one at a time because I'm not talking much. So let's do it one at a time. So if you feel, and I see myself as a financial crime specialist and as an anti-graft person, so I know that there's a lot of criminal activity went on at the central bank. Or I'm just saying, look, if you're going to charge them for criminal act, charge them for criminal act. Then you send that document to the board and say, look, this governor is being charged for criminal activity. Then the board now, in their wisdom, will say, look, if this guy is charged for criminal activity, you can't preside over us. So we will send the recommendation to the president that he has to forward you, for prosecution. Meanwhile, we'll suspend you. It's just, so nobody is saying that the central bank governor did what was correct. Like I told you, there are two aspects to legality. The substantive law, which we talk about in terms of whether there were fraud, and stuff like that. And then there's a procedural law. And you can't leave one of these aspects out in order for you to have legality. You must have the substantive law on your side. You must have the procedural law on your side. So for Bwaka, he has the substantive law on his side because a lot of wrong things really happen at the central bank. Why is not on his side is the procedural law. Okay, but procedural law is law notwithstanding because everything you want to do, there must be order. That's why all the time you see they attach law and then they attach order, law and order. So whatever you want to do under the law, there got to be some order to it. That's why even though the Constitution guarantees you the right to protest, but the police said, give us a notice that you want to protest. So every time the Constitution gives you a right, some kind of statute will further define that right, further give you a procedural map as to how you can exercise or benefit from that right.
And Anthony Jensen, so the whole issue of rule of law comes in, right? There is the Constitution and there is the rule of law, right? What's the essence of the rule of law if the president will just do as he pleases because he has the constitutional power and with disregard to the statutes that he also has the right to use? Because in this case, he can use the statute. The statute said this is the process to remove the person. And this thing has been litigated and he lost the battle, but he continues.
Okay, the phrase rule of law encompasses all the laws we're talking about.
Thank you. Now I asked the question.
No, but he's talking about constitution separate from rule of law. So I'm just adding.
You said all the laws. The Constitution is part of the laws.
Right. I was listening to you when you spoke. That's what I'm trying to make a clarification. The rule of law encompasses all of the laws of Liberia, particularly when we're talking about Liberia. So the issue here, and I think Freeman, I hate to do this, but I think we just have to be frank with one another on these kind of matters. The Supreme Court has a function. The president has a function. The legislators, they have functions. So the Constitution is the one that guides all these people. the president, in this matter, we're not going to go to all other matters, but in this matter, the president took an action, and that is the action for which this matter going to court. So we cannot be here sitting here.
And Anthony Jensen, there are checks and balances to all three branches. They checkmate each other.
Okay, I will tell you more
about the Constitution.
I will also let me give you a little emphasis about check and balance, saying about that. The checks and balances in government, when it comes to the president, and I'm going to the Supreme Court, when it comes to the president, let's assume that the president took an action like this. What checks and balance with the legislators convene and decide, say the president did not ensure check and balance because of that, we're going to impeach him? What are the actions?
In this case, the Supreme Court has checked the president and they've said that tenure is constitutional and the president cannot just remove any turning person.
So, and that's the falsity. That's the falsehood people presented in this matter. This is not a matter of tenure. This matter, let's follow Kaba's ruling on, I don't know what time he's going to come up with a ruling. If the petition that went before the Supreme Court, the governor argued on the basis of tenure, then we'll hear other things you're talking here.
Mr. Sear,
go ahead, Joe.
Yeah, ask a question. I'm listening. I listen to both councillors, and they have very strong points. But Councillor Jensen is making a point here, and based on that, I want to ask a question. He's saying that the case right now before the Supreme Court, it is not about tenure; it's about impeachment, which the Constitution, from the constitutional point of view, it does not grant to central bank governors. Okay, right. So based on that, if the Supreme Court already ruled 5 times, according to Councillor Freeman, which is NDPL and all these different cases, right, on tenure, right? And so based on what Councillor Jensen is saying, if this issue that is before the Supreme Court in this case, if it was about tenure, why would the Supreme Court then reserve ruling? Because if they already rule on tenure, why couldn't they just rule and say, no, but why they reserving? So could it be that what he's saying, that it is not about tenure, but it's about impeachment? That is why.
Okay, let me come in there.
Yeah.
The reserve ruling is just like an everyday thing to the Supreme Court. Because when you are writing a court opinion, you are supposed to be scholarly. You are supposed to be exact. You are supposed to be precise. Because what you write may last for the next 100 years.
Okay.
So normally, it is in the magisterial court that the judge can just sit and say, in fact, I decide this case, you do this, you do this. But once you step it up from magisterial, you enter the circuit court, and you go to Supreme Court, or you go to any what we call specialized court, what we call court of records. They would normally never give a ruling just on the point. If it's a minor motion, like you're in court and you file a motion, maybe for a minor issue, the judge can rule. But even sometimes in court of record, just on a minor motion, the judge will reserve ruling. So the reserving of ruling is a typical thing in what we call court of records. Only in the magisterial court, the judge sits and just issue ruling like that.
Okay.
All right. You have another question, Joe?
No.
All right. Let me bring in.
I think he's right on that. Let me be on the record, right?
Okay.
I mean, the issue of reserving ruling has nothing to do with the facts and circumstances, neither the law controlling this matter. So Kabak could come out anytime. Look, the court cannot do for any party what they feel to do for themselves. So whatever argument they have done, Kabak is only going to maybe do his own law research. The laws are cited. You're going to reread it and see and analyze it, compare with the facts. Who really is saying the truth? Who's saying the right law? These are the things you're going to look into. From there, he write his own law stuff. Maybe call his clerk of court, say this, take dictation and go do this and that. That's all you're going to do. But
and just another point. When you file a prohibition to a chamber justice, only one Supreme Court judge is presiding. In most instances, that's not the end of the matter, especially in high-level cases. That's just the beginning. Then you take an appeal to what we call the full bench. So a chamber justice is one single judge looking at the issues. He might rule. Sometimes the party might decide there's so much logic, we're not going forward. But most times, in a majority of the instances, they will make an appeal to the full bench. It means all 5 justices will now have to sit and hear the case. And in almost every instance when one or two of the parties are raising constitutional issues, it will end up before the full bench.
Very good information in there, because the matter is before Yusuf Kaba. He's the justice in Chambers. It's not before the full bench. And like you also said, the team representing J. Alosha Talu, they are saying the president acted unconstitutionally. Their reliance for saying that, based on my reading, is that tenure is constitutional. There's a way to remove a tenure position. It must be a cause, and not only the cause, there must be a due process that should be used, and the president is not going with that. That is their argument. Let's go to the phone line. We have the man, Flomo Livingstone is on the line.
Flomo Livingstone already first.
Yeah,
you always on my case.
You are live. I hope you will give my man Konyene some love today. Go ahead, brother.
Yes, please.
No, to be true, to be true, I give him credit today. I mean, he's speaking to the issue. I like that. I love when he speaks to the issue instead of just focusing on the present age. I don't like that. But look, the problem is, look, for me, I don't think most of the positions should be turning position. They shouldn't have most of the turning position, because most of the guys, when they're appointed, they don't even be neutral. They always side with the president that appointed into that position.
Right.
So I don't really think it's necessary. And my question to the two lawyers is, this legislature, when they ready to pass these laws, do they ready to consult with lawyers to read, or do they just make the laws by themselves? Do they have lawyers in their offices that they can consult with them before they make any laws to make sure it doesn't conflict with the Constitution? Because I feel like most of the lawyers, maybe the legislature, they just pass laws. I don't know if they can really consult their lawyers. Like in the United States, most of the senators and the representatives, they have lawyers in their office. Before they pass law, at least they consult with them to give them legal guidance on if it's going to conflict with the Constitution. But I don't know if it's the same with Liberia, with our senator and the House of Representatives, if they have lawyers in their office that they can consult when they're trying to make some laws that might be a little bit in conflict with the Constitution. That's my question to the two lawyers.
Thank you. Very good question. Gentlemen, let me go to the phone line again. We have the man, Pepsi Harris. Mr. Harris, you are live.
Good evening, Anthony. How you doing?
I'm doing well.
Look, Anthony, JC, the thing is in black and white. It's text right there. You can just come to this kind of substantive platform. Be talking about the president have the right to appoint, and so he can do anything because he can appoint. The Constitution is there. The appointment power is there. Who the president can appoint? If you read Article 54, it's in black and white. The people that the president can appoint, they are there. If the central bank government is going to be one of those people that are going to do, no need for the statute here we have in here today. You know what I mean? There's no conflict here. Let's be clear about that. The president does not have the right to suspend the central bank governor. You either impeach the man or you leave him alone. In as much as the guy is bad for the institution, there's a procedure here. Like, it's not a lawless place. Like the Anthony Freeman noted, we don't have things in Liberia. The president is not above any law in Liberia. You can't come to the kind of substantive platform and the president cannot do a power grab. That's a power grab. You giving power to the president and the constitution does not even ascribe to him. And in black and white, it lists all the people that president can appoint. So the central bank governor is not one of them. So you can't come here and come talk about the president get records because you get appointment power. It's not a carte blanche. It's not a carte blanche. The president cannot get appoint anybody.
Thank you, Pepsi.
This time you making no kind of argument and you acting like you're some kind of top lawyer, yeah, man. It's crazy.
Thank you. Okay, before we go back to the phone line, gentlemen, two questions before you. Anthony Jensen, you go first.
Okay, thank you so much.
Go ahead, Anthony Jensen.
Okay, I take the last one, right? The first one will come. I like when people are arguing. And again, I don't blame people. I don't blame the ordinary people, right? I understand I get mad with lawyers who's supposed to know better, and sometimes they don't.
I don't know how you say they're supposed to know better. Law is about argument.
No, not about argument. Law is not about argument.
As lawyers, we used to that kind of thing. So that means that thing got no meaning. Let the man just talk. We used to it.
Go ahead, Anthony Jensen.
You get told that.
It's typical in a courtroom for people to do those things. So
I think I have to go tell the law now because this thing is getting. Go ahead, Anthony Jensen.
The issue here is the last caller. Because of his limitation, he speaks the way he speaks. And I say that because the Constitution said the president.
Did you understand his point?
Yeah, I think he's talking about the central bank is not, central bank officials are not one of those persons, or the central bank is not listed under the president making appointment of those positions and removing anybody on the position. That is crux of the matter. So meaning he didn't say some other thing, but to rationalize
that's his first point. And the other point is that there's a statute that lay out the process through which any member of the central bank can be removed. I'm talking about the government.
That's what I'm saying now.
Okay,
so then the Constitution says the president should appoint officials of government, and it listed some of those officials of government. Even the very Constitution, if you go to, I think, Article 89 or something at the back part, it says it listed some of those statutory institutions, that the GSC, the National Election Commission, the how you call it, the Civil Service Agency, right? And then it said other agencies can be created. You understand that? So when you create an institution, then
the president can appoint, right?
Very good. Very good.
So let me hold you there, Anthony Jensen. Let's have the conversation.
No, let's get it going.
It's the same way the Constitution gave the power to the legislature to create laws governing such commissions and agencies, and they have done so. In the case of the central bank, you said no, the president should not listen to that.
No, I'm not disagreeing with you that the legislature don't have the right to create laws. But I want you myself to discuss the matter so the man who call can be educated sufficiently.
Go ahead.
So he cannot shame himself next time when he calls. When the Constitution provides,
I just do that thing with the lawyer. Don't extend it to the callers.
Let's see.
For me, you can say all of that, but don't extend it to the callers.
I didn't know plenty of both. Let me put some sense in here. When the Constitution says statutory institutions must be created, when those institutions are created, those institutions need officials of government or people to lead those institutions. When that law is created and it says, well, you must have 5 directors or 5 executive officers or board of directors or whatever you call, then you go on Article 54 now and you find what Article 54 says that the president must do. The president has all right to appoint all officials of government. So because you are created one institution and officials should be appointed, then you go for the Article 54. So Mr. Koller, please understand that as of today's date, that when institutions are created, it's left for the president to appoint as provided for under Article 54.
Anthony Jensen, why is it that?
But you have to also to comment. So before you come in,
why is it that in some statutes, the right is given to the board to recommend to the president? Because you are saying the president has the power to appoint, and I agree, he does. But there are some statutes or some commissions, the board will have to recommend to the president before the president appoints. Are they taking away the powers of the president?
No. Procedural, I studied corporate law, right? We don't let emphasize those things then. When a corporate law is created, like in the case of the central bank, and you set up a board, or let's say, for example, I'm sure you're running either a not-for-profit Or let's say, for example, your institution here, let's assume you had a board.
Yeah, we do. We do have a board. Go ahead.
Very good. If you have a board, the board has specific duties. You could make mistakes to ascribe certain action to the board. When in a corporate sense, it makes no sense, or your board should not act. When you act, anybody who challenges this FOL and when the court will look at what corporations supposed to perform, what they're supposed to do. In the case of the central bank, the governors or the board of directors, the president of Liberia, the constitution of Liberia, being like the article of incorporation that spell out the duties and functions of board of directors or executive officer or whatever is said in the article of incorporation. In this sense, the constitution of Liberia says the president of what? The Republic of Liberia should appoint and remove anybody.
Point made. Answer the second question that the first caller asked, Romo Livingstone, whether or not our lawmakers have lawyers that they consult either in their offices before passing law, because he feared that some of the laws they are making, they are getting in conflict with the Constitution.
That was a very good question, and it's a concern for all of us that sit or that are interested in governance. Every legislator of Liberia needs a lawyer. Even if a legislator is a lawyer, needs a lawyer. Because everything that they're doing, even a piece of legislation, needs to be read thoroughly and catch those legal phrases or those legal arguments that are raised in those institutions or those instruments. To get a lawyer, when I was at the legislature at the time, we had Jennifer William, my former professor. He was the lawyer for the legislature. So most of the time, like you talk about removal, or even among the representatives themselves, if they want to suspend any of their colleague, that become an issue. They send it to the lawyer. The lawyer will make his own analysis, or look at the file, make his own analysis, and make a recommendation. What is happening today, I do not know, but I'm very certain that there should be lawyers assigned to the Capitol to guard these people. But here's the thing. Let us assume that they don't even consult lawyers and they pass a piece of legislation. There are procedural ways to get rid of that law, especially so when that law contravenes the Constitution. Like, for example, we're talking about this issue. If there's a law that says impeachment, before you remove the central bank governor, you must impeach him. If I'm in any case of that, you can trust me, I will move for removal. I'll move for dismissal on grounds that impeachment is granted by the framers and not by the legislature. So the legislators themselves at the time should have known better that impeachment, it is not they that should grant impeachment or to extend impeachment to other public officials. The officials that the framers wanted to be impeached is clearly spelled out under the Constitution of Liberia. So if any other law that says officials must be impeached, I would say, hey, dismiss it because it is on the right of the legislature to grant impeachment. They cannot extend impeachment to other officials of government.
Let me bring that caller in quickly. He dropped off.
But you asked me to. You said we should react. I mean,
let the caller ask a question, and then you will come in, please. I don't want to lose this caller.
Okay,
Mr. Khaled, go ahead, sir.
Making a very serious. I mean, it's just common. I think, some of us are not lawyers, but we all want to engage, a little bit of law. So, we all know that the Constitution gives the president the appointing power and the firing power. It's clear, all right? So, with the central bank and all the other agencies that are created where the president can just fire, the president can suspend. Besides, the president, the board will recommend a central governor. The president has to agree with that central governor before he can actually send him for what? A confirmation hearing, and before he can commission. So the president has the power to suspend. In this case, and even in the central bank statutes, there's a description that says the president can suspend with cause. In the case with the central bank, there's a cost. All right? There's a cost that makes the president so sustained. Let's agree that the president will not keep fire. In this case, the central bank cannot be the reverend, the player at the same time being the spectator. The thing the president has to do is look, when there's a cost, look, my friend, just move, let us do the investigation. If everything is right, he will come back. You can remove. That's the point. The other attorney is basically that the president did not remove this guy. He wasn't removed. He was suspended.
Right.
Thank you.
Suspension and removal is different.
Thank you.
Thank you, caller. That's a good point.
All right. Joe, any other comment or question that you may have?
Yes, before we go to Councillor Freeman, this is the comment that I have. I've raised this here on point several times. Whenever there is, like now, I'm not a legal person, like I'm not a lawyer, but everybody generally have some knowledge, right? But if I spoke to something right now about something legal, everybody said, no, you're not a lawyer, right? Okay, I agree. But look at that's the problem I have with the setup and the governing system that we have, right? So we have a whole bunch of people that are making law, but they are not lawyers. You are making laws, but you are not lawyer. A whole bunch of you guys can't even read. So if we're serious, because these are so many recommendations, we can look into this. Because of that, any guy can just wake up from eating kobo, he shares some bag of rice, and he enters over there. And then we are wondering, how did they pass this concession? How did they agree for APN terminal to grab the port for 25 years? So we should put some provision in there. The minimum requirement to at least become a congressman is you must be a lawyer.
That's a good point. That's a good point. But the
Anthony Jensen, let Anthony Freeman speak.
Sorry.
Anthony Freeman, please.
Sorry.
Okay. Let me start with Tawo's point. If you have a whole bunch of lawyers in there, I can tell you it will be a very bad legislature, because we lawyers, we don't normally use common sense. We will write very complicated things, and that law is supposed to be applied by the ordinary people. We will make it very complex until it might be difficult. So it is not required. It's not a good thing for lawyers to be the one to write those laws.
Really?
What is important is for them to have legal advice when they are writing the law, because in the law, there is something we call the ordinary man's standard. That is the interpretational approach that the court uses, ordinary man's standard. So the lawyers can go and describe things in very complex language. It gets to the court will say, what would an ordinary person who read it in, what would he have interpreted this to mean? The answer for that question is what the court is going to rule on. Ordinary man's standard. The court is not going to rule on that very complex thing that the lawyers wrote. So that's just to say it. So it is not required. It is not even a good thing for there to be too many lawyers there, because they will complicate matters and people might have difficulty implementing those laws. On the other hand, with respect to the laws written in the past, that law was written 1999. So that law was written before the UP and CDC back and forth. So it was not written against Bwaka or for Weah, or for Weah against Bwaka. It was written because at the time, people felt that when you are running the central bank, almost everybody might want to come to you asking for money, asking for this. So they wanted you to make independent decisions. So they created a law to make it very easy for you to say no to people and not have to worry about your job. That's why that law was created. It was created in 1999. If they did something afterwards, fine, but it was created in 1999. The other thing I want to say is, no matter how scholarly the person who is writing the law, there is no law that you can write that is going to be perfect and includes everything. That's why we have courts. We have court because the court recognizes that no contract, no statute, no constitution can have everything that needed to be in there. That's why we have interpretation of the law. That's why you have statutory interpretation, constitutional interpretation, and you have an approach to lawmaking. That's why people bring in constitutional doctrine. Because when the statute is not sufficient, then you bring in the doctrine. For example, you say the doctrine of separation of power. Or you bring in the doctrine of stare decisis, that when the Supreme Court decides a matter, that matter is decided, unless different reasons can exist for them to change their decision. So there is no need for you to say, oh, the law got to be in or is sufficient, but there can be constitutional interpretation. So now we discuss in the Central Bank statute. We say, okay, suspension is omitted. But what can we resort to? Yes, we can resort to the Constitution. We might resort to corporate law. We might resort to commercial practice. We might resort to criminal law. We might resort to administrative law. We might resort to case law. So it's just to let you know that the law is dynamic. And there is no such thing as the law will be complete, exhaustive, because you're using language, and language is imprecise. And that's why the code will come in to give us the interpretation. I think what my colleague is trying to give for the impression that when the Central Bank, when the Supreme Court speaks, is not final. The Constitution is final, but the Supreme Court decides what the Constitution says. So which one is final? It is the Supreme Court. Whatever the Supreme Court is the law. It's final. And unless they change their position, that law is final. There is nothing you can do about it.
Thank you.
Gentlemen. The issue here, before the question is better, I just want to throw a little point over there because Freeman is not doing well for us here. Lawyering is a noble profession. And anyone who decides to go to law school that is well learned will know what it means to occupy any position and act rightfully. Liberians are not aware that there are ethics that guard lawyers. Even as I sit here, if I mislead, I can be chastised because of that. If I wrongfully say things here, and I knowingly say things here that I should not say, I can be penalized for that. But most of us, like he says, your question asks, if you had lawyers, noble people in the legislature, you will have a refined decision every time. Why? Because the first thing is no lawyer should be in the business of wrongfully enacting a piece of law, assuming this was a legislative thing. No lawyer should be.
You re-arguing or you just making a point?
Say that again.
You re-arguing or you making a point?
I'm not arguing. Give me a chance now. Let me learn.
Yeah, the point is getting longer.
I think you're misleading the people. So that's why I just want to context it so you understand it.
Yeah, your papa.
No lawyer, and again I emphasize, no lawyer. To be lawyer is a noble profession.
So why particularly I misled the public on?
Anthony, just think, I think you will agree with me if I said there are bad lawyers too who break.
That's what I said.
Because
so if there are bad lawyers,
when one is a lawyer, that person will do no wrong. They will do the right thing all the time. That is not true.
No, what I'm saying. The reason why I brought you about ethics is because lawyers can be penalized on an ethical note. That's the issue here. So assuming that you know that impeachment is spelled out under Article 54 and you misleading the public on that. If you had the ethics and grievance committee sitting over there and anybody pick up my argument from here,
thank you.
I can be sanctioned because of that.
Thank you, gentlemen. We have to bring it to a close. Folks in cyberspace, this is how we are going to come to the end of this discussion. Joel, I want you to give your comment, and then we will get to the lawyers for their closing argument.
Yeah, gentlemen, I really appreciate being on this. I really enjoyed the discussion, and I see how passionate we all are about our country. But to my point here is that I hope that the government will do well, because I listened to the program last night, and each time they talk about audit, everybody start pointing to how it's going to destabilize the country. So I don't understand what Liberians really want. If money was stolen, it doesn't matter who it is. If this government decided that they were going to do the right thing, they don't have to go back to 2018 to start. They can start with what's in front of them. As Liberians, our concern should be that the Liberian money gets stolen. And if they find the proof, be it the ex-president, be it whoever, they should be penalized and they should be held responsible. I want us to be honest, because look, our country is dying. Our people are struggling and they're suffering. There is a lot of wealth in that country, but it's being looted out, and something must be done.
Thank you, Joe. Thank you so much. Gentlemen, for your closing argument, I want you to close on the note of the rule of law. Looking at the statute, how can the rule of law be abided by and applied in this case? Who wants to go first? Can go.
Johnson, you're not going first?
I don't mind going first. I mean,
Okay, go ahead.
You can't change your facts and circumstances or whatever we have discussed. But here's the fact.
Mm-hmm.
The rule of law, as I said, if Liberia is a country of laws and not of men, it means anyone who is in the business of service to the people should respect the Constitution, the statute, not just the statute, all statutes, all of the laws concerning in the sequence of what make Liberia to be a respected country among the Committee of Nations. Nobody from the president down should be a disrespecter of any piece of law in the country. It doesn't matter whether the law favors you or is against you. You must be a man. Sometimes you say, why? You can cry and wipe your tears and say, well, this is Liberia. It needs to survive and stand the test of time. On this matter, it is hope that Joseph Boakai himself, on the basis of his suspension is not removal. I like your last caller, and that was a salient point. Suspension is not removal. So it means all those a criminal has served in administrative position, if you are served as manager of any institute of anybody, any group of persons, it has the right to suspend a staff pending an investigation. Because suspension, it will give him the greater latitude to do further investigation, get more facts before you can write that final letter, signing, removing, or suspension in final, or removal is the best word for that. So in the face of this issue, Joseph Boakai has all constitutional right to have suspended not just the central bank governor. He has a right to suspend all of the board of directors if he feels this matter is so great to the extent where Liberian people money must be accounted. In the final end, after the 6 years, we all will be blaming Joseph Boakai for what? For corruption, for stealing the people's money. So when he's taking action at this time, if he has removed the central bank governor, then that will be an issue. Whether or not the removal was on the basis of actions spelled out under the Constitution of Liberia. But the fact he has suspended, meaning he's taking further actions as to what to do next. So for the governor to have run to the central bank, run to the Supreme Court, he's in error. Why?
Is that not his right?
It is a right. I'm not saying it's not a right. It's a right to go there. But I'm saying he's in error in the sense that he cannot go and plead that he should have been impeached when the president has not even thought of removing him yet. The president will say we suspended him pending an investigation or pending whatever action the president want to take. So he went into the court. I'm not sure the court will tell him, say, oh, you're right. Go ahead and do what you're doing. Go and stay at the central bank.
Thank you.
So again, in finality, we want to say thanks for inviting us, and I'm glad I'm sitting with you distinguished gentlemen. I hope you'll bring some women in our midst next time when we're having the kind of discussion. I know there are many pending female lawyers all around the place.
We'll make effort. We always try. Anthony,
Yeah, thank you.
Freeman, your closing argument, sir.
The Supreme Court operates by a legal doctrine called stare decisis, meaning what we have decided, we have decided. Unless we change our mind, that is the law. So when in 2008, the House of Senate tried to remove the pro temp, and they said they only suspended him, but they didn't remove him. The Supreme Court said, and I quote, the Constitution does not distinguish between whether the removal was temporary or permanent. It only forbids removal in the absence of 2/3 of the membership of the Senate. Procedural. So the Supreme Court already decided whether you suspending or you dismissing, you must follow the legal process laid down. The other thing is, the since stare decisis mean there is nothing to discuss in tenure law again. It's constitutional. Anybody who is operating on tenure, they got it legitimately. You want to remove them, you have to go and open that specific law and find out what the procedure that has been established in that law for you to remove them. We should always remember that there are two aspects to legality. The substantive law, for example, somebody committed fraud, they committed crime, murder, rape, that's a substantive law. But does it mean that you can just grab them and put them in jail? No. You have to investigate, you have to charge them, you have to take them to court, you have to empanel a jury. After that, they have to appeal, go to the Supreme Court, motion back and forth before you finally declare them guilty, before you punish them and put them in jail. You can't say, oh, because somebody committed murder and you were standing on the scene and the person committed murder, so you just grab them, you put them in jail. No, because there are procedures laid down on how you can convict a criminal. So these are things that we are saying. And when there is no law will ever be adequately written, that everything that's supposed to be written will be seen ahead of time, 50 years, 100 years ahead of time and written down. No, that's why we have legal doctrine, so that when the law is inadequate, we resort to legal doctrine, established legal doctrine that have been in existence for probably hundreds of years. For example, constitutional interpretation. When the Constitution does not list a particular item, it means it didn't give it to you. Okay? So you have statutory interpretation, you have commercial practice, you have administrative practice, that when you set up a board, it is the board that will take the decision. You can't set up a board, then while the board is in place, then you go take decision and leave aside the board. So if something is missing in the central bank statute, you can resort to administrative law, you can resort to corporate law, you can resort to criminal law, you know. The other thing, the last thing I want to note is, I myself, I'm a anti-graft advocate, I'm an anti-graft lawyer, I'm a certified financial crime specialist. So I'm not supporting what Talu did, but I'm saying that following procedure is part of legality. So if you fail to follow procedure, it is just as lawless as whatever Talu and his colleagues were doing at the central bank. So you are not distinguishing yourself. So, and it's very simple. Just follow the law. You know, eventually Talu could have been charged. Eventually that charge will go to the board. The board will say, Talu, well, they charge you for criminal act. We can have allegations of criminality and you be running the bank, so you have to either tender in your resignation or we might be constrained to, you know, remove you. But for us to keep encouraging the president or whoever is in power that you can, if you are angry, or if you're in a hurry, there is no need to follow the law. You can just do what you want. You will continue to create a situation where Liberia will continue to stumble, because it will create confusion and chaos, because at the end of the day, people tend to resist when they perceive that whatever action you are taking is illegal or is contrary, to law. So I would like to end on that note. It's been, a nice time, and I hope we have been able to, provide some clarity. I recognize that it is a gray area because it's not mentioned in the law, but I also say that, when those kinds of things happen, you can go to case law, you can go to, administrative practice, you can go to criminal law. There's so many ways you can pull together everything that you need to know and then say, okay, even though this thing is not stated in clear black and white terms, but based on all aspects of legality, this is what we're going to. So I really believe that it's unlikely that Waka is going to prevail because it clearly seems like he's not following the procedure in order to remove this guy.
On that note, this is how we come to the end of this edition of Focus on Liberia Justice Forum. We will now close with our song that says, "We are all Liberians." Thank you and bye-bye.
We are Liberians.